when you die, for example, there are two instances. You can die with a will, that is, we call your estate tested, and you can die without a will. We will call that scenario intestate. So when you die without a will, there's provisions that normally kicks in, and there are people who are stipulated as far as inheriting your estate is concerned. So they are beneficiaries, and the first beneficiary normally is your wife and your children. So your children comes in two aspects: your biological children and any child that you've adopted, or they can that you are like kinda providing before you died. So they're like your beneficiaries. So they are just like your children, like your biological children. So the law does not differentiate between a biological child and a child whom you have adopted. As long as they were under your care, you are providing for them, they stand on the same equal footing as though they are your biological children. So the law is very clear. It's not about you having given birth to them biologically, but as long as they are your beneficiaries, they were like, you are providing for them, including even your parents. If you are providing for your parents when you died, even your cousins, even your friends, if you're providing for your friends and they can confirm that indeed you are providing for them, the law provides that they can take a stake of your estate.
Wakili, there's often a legal assumption that once a child is born in wedlock, then the husband is presumed to be the father automatically. And right now we are seeing rising cases of infidelity. The DNA technology is also very quite high. The prices of DNA, I'm looking at it, the public hospitals give it at 27,000 thereabout. And of course, private labs as well at 100,000 Kenyan shillings thereabout. How sustainable is that presumption? You know, that once a child is born in wedlock, then, you know, the husband automatically is the father. And from where you sit, is the law really evolving to meet that reality?
You know, the law as is, it reflects our society. So there is a rebuttable presumption, and underline the word rebuttable.
Yes.
There's a rebuttable presumption that any child that is born within wedlock is a child to the parents, to the father and to the mother. So it doesn't matter otherwise. So if, and I say rebuttable because if the father feels like this is not my biological child, then the father can go to court, and the court, only court, is allowed to issue an order for DNA to be done. And once the DNA is done and it is found that now the child is not biologically the child to the father, then the responsibilities to the father will end. And I'm saying rebuttable because once the DNA confirms that you are not the father, then your responsibilities, you can choose to either step up and be the father as far as being the father is concerned, or you can also step down, and whoever is responsible will have to step up as a matter of law. So yes, as we speak right now, the law needs to evolve. You know, our laws reflects our society. Our society as is right now is that any child that is born within wedlock is the child to the parents. But that presumption can be rebutted by DNA, for example. Yes.
Wakili, when we were starting this conversation, I mentioned somewhere on the intro that we'll be unpacking what the law fails to address in regards to the child's right to know their father. Just where are the gaps, if you're talking about it?
The gaps as far as the right to come up again?
Yes.